Hey, everybody, and hi, Ken. My name is John Mancini, and welcome to the OxyMorons. And for those of you that haven't joined us before, the concept of the show is that I have always been impressed with people that possess two somewhat contradictory skills. One is the ability to think strategically, and then the second is the ability to execute tactically. And so those people are a rare breed. And it struck me that it might be interesting to talk to those kinds of folks. And it's a byproduct of COVID times. And so we're in the second season now, and it's been really a whole lot of fun. So, Ken, welcome to the show, and it's nice to have you here.
Thank you for inviting me.
So for those of you who happen to be on LinkedIn in particular, you can comment on the show. All you need to do is post a comment, and then through the magic of technology, it somehow materializes here. And you can become part of the broadcast. You can also use that to ask a question or post a comment. And we'd love to have you as part of the show. I'm also told, although it's I haven't been on the receiving end yet, so I don't really know exactly how this works, but in LinkedIn, there are all those wonderful little like clapping hands and, thumbs ups and all that kind of good stuff. So if you're there and you happen to do that, then let her rip on those. And we'd love to see those as part of the broadcast later on. And I will make this a blog post for next Monday. So you might want to watch for that as well. So let me start off before hopping into the Sedona conference and your background and all that kind of stuff. A couple of get acquainted questions that I like to ask, Ken, which is first thing, if I was to secretly access your Spotify or Pandora playlist, what would I be surprised to find there?
Nothing. There is no Spotify or Pandora playlist. You may have had a couple other guests with that same response. No, I pick up music off of Amazon and off of Soma FM, which is a obscure little FM, or not really, it's an internet radio station out of San Francisco. But right now I'm listening to the least respected musical instrument in the canon, and that is the accordion. So I'm listening to Gotan Project and to the B&B Project out of the Ukraine, which some people may, if you watch a lot of Ukrainian morning television, you've probably seen the B&B Project. That B&B stands for the bandura and the button accordion. Those are the two instruments. And then my favorite is on YouTube, and that's a kid by the name of Thibaut Trosset out of Paris. And he does pop covers on the accordion of everything in the world. Wow. Some of these pop covers are really cringeworthy. Like, do we need another cover of the songs from Frozen? I don't think so. But his classical covers, last night I was listening to the Brandenburg Concerto done for 3 accordions. His Daft Punk covers are absolute genius.
Oh my goodness.
And I recommend that people take a look at Thibaut Trousseau in the, I think it's called the Persiflette moniker, which is a series of accordion covers.
Well, I will post a link in the blog post that maybe we can spread the word about accordion covers moving forward. How about any TV binges during COVID that you particularly are either fond of or embarrassed about?
It's been 2 years, so you can't remember what you were doing 2 years ago. But I think, like everybody else in the world, I started out by rewatching all of The Marvelous Mrs. Maisel again and again because it's wonderful, and parts of it are like my childhood. And then later on, Wheel of Time was another one that I love for science fiction fantasy people. Right now, I've just completed the second season of Vienna Blood, which I highly recommend to people.
I don't know that one. Okay.
It takes place at the turn of the last century. It's a student of Sigmund Freud who doesn't have much of a medical practice, but he helps out the police with this new science of profiling, of criminal profiling in Vienna in 1905. And the production values are wonderful. It's just you just feel as though you're transported. And now, of course, we're in the middle of Around the World in 80 Days with the former Doctor Who, David Tennant.
Yes.
And again, the production values are great. Has nothing to do with the book. If you're looking for something faithful to the book, forget it. But it's better.
Yeah, we're big David Tennant fans, so that's on
Yeah.
my list coming forward. So
Yeah, but my favorite thing that I really do binge is from YouTube again, and it's a whole genre of videos, often 6 to 8 to 10 hours long each, called cab rides. And what they are, they simply put a camera in the front of a train, and the train goes. So you can travel from, for instance, on the Adriatic coast from Bar to Sarajevo, takes about 8 hours, and you're on the train.
huh.
There's no dialogue. There's no plot. All you hear is the engine and the tracks, and you're going through the most fabulous scenery in Europe.
Wow.
And you can take Oslo to the Arctic Circle in winter, which is, if you want to get some sleep, taking a train through a snowstorm is the way to go. Or you can do the French Riviera, and
Nice.
you just sit back and zone out.
Well, terrific. Those are among the more interesting answers I've gotten. So thank you for that. So tell me a little bit about Sedona, and tell everybody a little bit about your background and what
Sure.
Sedona does and all
Sure.
that kind of good stuff.
Well, it's the Sedona Conference with a capital T. That's part of our trademark. And it started back in the late 90s as a continuing legal education provider, but with a difference. And that is that we used to actually meet in Sedona itself, which is a town about 90 miles north of Phoenix. But it's now too large. The town can't handle that. So we meet now around the world. We have conferences which tackle cutting edge areas of the law for which there isn't a whole lot of guidance yet. And of course, that would involve lots of technological issues in the law, but mainly around the issues of intellectual property, complex litigation, antitrust law. The conferences don't have lectures by law professors or judges, but we have dialogue, panel discussions with leaders of the legal profession, those same law professors and judges and senior litigators. But the purpose is to try to frame questions around these cutting edge issues. Then we have working groups, and we have about a dozen different working groups, and they meet and they develop guidelines and commentaries and best practices on those questions that have been developed. All of the commentaries, all of that work product is free to the public. It's all on our website, which you have up on the screen, I see. So people can go under publications and just get lost. There's tons of stuff there, and it's all free. But the way that the Sedona Conference works, which I think is different from any other legal organization, it's not a bar association, is that we're very big on inclusive and diversity. We get everybody who's a stakeholder in an issue, whether or not they're lawyers or technologists or whoever they are. If they got a stake in the issue, we want them at the table. We engage in dialogue, not debate. We actually talk and listen to each other, and we develop consensus. We don't take votes on anything. Everything has to be by consensus, and that produces incredibly authoritative papers. There are primers, which are introductions to an issue, commentaries, which are more like law review articles, but they go take a deep dive into an issue, principles, where we attempt to establish norms of legal behavior in an area, guidelines and best practices for people who are practicing in that area. These get cited by the courts a lot because the courts recognize that they're nonpartisan, they're consensus-based, and they're put together by people who are actually in the trenches and know what they're talking about. And that has, over the past 20, 25 years, that has given the Sedona Conference a real visibility in the international legal community. Just last week, we were having a conference on cross-border data transfers. We had the data protection authorities from Brazil and France and England and Germany and the US and Canada, all sitting together and talking about these issues. You don't see that in any other organization.
Yeah, and it's I can tell you as an outsider, when I talk to people, extremely well-respected organization and kind of the gold standard when it comes to the combination of legal and technology. So let me hop in, and if anyone would like to comment, please feel free to do so. And I'll try to pay attention to the comments and multitask. And Ken and I were talking about that you can't really multitask before we got started with this, but I will give it my best bet. But one thing that's been on my mind recently is, and I am not a lawyer for everybody's benefit, and I'm hardly even a technologist. I'm not a technical person. I was a history major going back a million years ago. But one of the things that I've found really interesting is that, as we apply analytic tools to mine information, that we're getting more and more sophisticated in being able to plumb just about any data source to find all those hidden tidbits that are out there. And it strikes me that there's some sort of an overlap there between that capability and how the courts are viewing eDiscovery questions. Mm-hmm. Maybe you could just talk a little bit about that intersection in terms of privacy and eDiscovery and technology.
Yeah, well, for a lot of judges, their introduction to AI has been through the concept of TAR, of technology assisted review, which is kind of a subset of AI and maybe separate depending upon how sophisticated you want to be in the analysis. But really, AI comes into the courts in three different ways. First is when artificial intelligence, when the application itself is an issue. So we have in the courts right now, we have a lot of criminal cases that deal with police surveillance and deployment using AI. When does the AI simply become a high-tech version of racial profiling, for instance? When is it a legitimate law enforcement tool, and when does it simply confirm people's prejudices? So that's one set of issues. On the civil side, you have the same issues in employment and credit discrimination cases. When is AI an actual efficacious tool for making business decisions, and when is it simply confirming people's prior prejudices? So that comes into the court as a substantive issue. But as I said in the beginning, most judges are introduced to AI or AI-type concepts when in civil discovery, there's been a question about how the litigants answered either the courts or the opposing parties' discovery requests. And there, it's kind of less a sharp issue as it is in criminal law, where people could go to jail for a wrong decision. There, the standard is it reasonable? Is it a reasonable way to get the answer to a question? Is to use artificial intelligence and to unleash AI type tools on these huge collections of information, be that giant collections of email. We're into the terabytes. What's after terabytes? Is that a byte?
I don't know. Very, very big bytes.
We're getting in there, right? Or text messages or videos, where there's no possible way that human beings, even a large group of extremely well-trained human beings, can go through all this material and come up with answers to a question. You've got to use some form of technology. So the courts get into this because in the initial stages, it's up to the parties themselves to decide how they want to answer questions. That's right in the rules. But the answer has to be reasonable and has to be based on a reasonable investigation. And so if there are questions about whether or not they produce the right results, then courts are going to start looking behind the curtain, and they're going to say, okay, we would like you to describe for us the process you went through to produce this document production. That's very difficult to do if the process is a black box. Yep. Which is, a complex algorithm that nobody understands and that not even the developers understand. Because once they unleashed the algorithm, it began to teach itself, and the algorithm began to evolve all by itself. So that's a difficult question, but it's a question of reasonableness. It's not a question of, is it exactly right? It's a question, is this a reasonable approach? And I think the answer overwhelmingly by the courts has been yes. It is a reasonable approach under these circumstances. Then there's a third form of AI that is now being used, and that's AI being used by parties to actually predict what the court's going to do.
Huh.
So they take the past decisions of that particular judge or that particular court, and they began to use AI to actually map out their strategy. Now, on the one hand, you can consider that to be really good lawyering. Great idea. And in fact, in the old days, back in the 1970s and 80s, we used to actually keep files in my law firm of, by judge, so that if you were going to appear before some judge, you go to the file and you get an idea of how this judge treated people in the past. So that's nothing new. But now it's become a question of, wait a minute, from the judge's point of view, are you actually engaged in forum shopping here? Are you trying to manipulate the results using AI? That hasn't been tested yet, but that's on the horizon.
Does that enter into like jury selection processes too?
Absolutely. It has become the tool of choice for these litigation consulting firms that do a lot of work in jury selection. That is to predict, again, using these same AI tools that are very questionable in the criminal context, to use them to try to predict how a jury is going to behave.
So I know in the eDiscovery arena, there's this concept of making the relevant facts available at proportionate costs. That in other words, there has to be some sort of balance between the two. Is technology changing that balance?
Yes, absolutely. As I said, there is no way that we could possibly use the methods that we were using 50 years ago on our current information technology infrastructure. 50 years ago, you were dealing with, a box of documents, paper documents, or maybe in a big case, there'd be a file cabinet full of documents. Well, what's a file cabinet full of documents in the electronic world? It's maybe a megabyte. It's nothing, right? Today, we have so much more information in so many different forms that you must use some form of technology to try to understand the technology that people are using in their day-to-day lives. We have no choice. And in terms of the efficacy, first of all, it's incredibly cheaper once you get over the hurdle of developing the technology to begin with, which is very expensive. But once you start implementing it, the marginal cost goes down tremendously. So you've got an expense point of view, but it's also far more accurate.
Yeah.
I mean, in the old days, you'd have a team of paralegals sitting in a warehouse, going through documents, living on pizza and Diet Coke for hours and hours and hours through nights and weekends. How accurate do you think those results were going to be? Not very accurate. But the machine does not need any Diet Coke or pizza, and it will just keep chugging along. And, depending upon the system you're using, it actually is improving its accuracy as it's going along.
Are there any elements in the courts where you find that kind of skepticism that you find in other technology realms, where people just don't want to believe that the technology is better than a person doing it?
We still get that. We still have judges who insist. In fact, we had a high-profile case a few years ago involving the personal attorney of a former president who will remain unnamed, where they, the police, law enforcement, had gathered tons of stuff from that lawyer's apartment, maybe other sources as well, and they had to quickly go through it, and the judge was very skeptical of proposals to use artificial intelligence for that, and ended up doing ordering a traditional document review. In that case, I don't think that there was any huge downside to doing it that way. It just took longer and was far more expensive, but it was all government money, so nobody was complaining.
Again, if folks want to post a comment or a question, please feel free, particularly if you're in LinkedIn, and I'll try to keep an eye on those. This is a little bit of an esoteric concern for me, Ken. I just want and see if it registers with you. I think a lot of people know I've spent a lot of time working on this book called Immigrant Secrets, and spent a lot of times in genealogical circles and all that stuff. One of the elements that's really interesting right now is the combination of huge data sets with DNA information, and to use that in to basically triangulate closed cases so that you can is all that bubbling up in the court system in terms of changing the way people view that kind of data?
Absolutely. We're seeing it most sharply in what's being done with Northwestern University in their Innocence Project. Is that we're discovering as we're going back to cold cases or old cases where there have been convictions based on traditional and somewhat circumstantial evidence, that no one really looked at these other forms of evidence before. Maybe they just simply weren't available at the time, but they're discovering that our view of the infallible criminal justice system is quite warped. And that indeed there are lots and lots of cases where once we start looking at the scientific evidence here, particularly DNA, and matching it up to other DNA sources or some of the other evidence, we're finding some real problems in the convictions that were handed down years ago.
So I've spent a lot of time, as you have, dealing with information governance professionals over the years. How does when you think about all those issues that you talked about, how does that change the skill set that these folks need to have moving forward to continue to be relevant?
Well, the profession that we now call information governance, 5 years from now we'll call it something else, has always been evolving. Information governance professionals today are coming from a variety of different backgrounds. Some of us are coming out of the law. Some of us are coming via librarianship.
Yep.
Others are coming from an information technology background. But essentially, we're following the same paths. And it goes from records management, the conventional records and information management, RIM approach, to corporate compliance, which is, the reason why we have RIM to begin with. Then it evolves into eDiscovery. Whether or not people are lawyers, they're getting involved in eDiscovery projects. Now, eDiscovery people are finding more and more that they are becoming information governance people. It's getting way beyond the just litigation. And now we have entered into a new phase entirely, and that is a concentration on privacy issues. Privacy is where it's at. And that already is evolving from privacy per se to information security. The sine qua non of privacy, but it involves a lot more than simply personal privacy. So, few of us who graduated from library school at the end of the last century thought that we would be evolving into InfoSec experts, but we are. And for myself, I'm retiring.
Do you find that the everything that's gone on during the pandemic and with remote work has put real punctuation points on that whole question of InfoSec and privacy and all of that?
Absolutely. And that will be the theme of my presentation and that of many, many other people at the upcoming MER conference.
Oh, good hopping off point on that. You've done MER for a long time. Tell me a little bit about your experience and why you think that conference is important.
I think I may be the longest running MER presenter alive. I may be. You can ask some of the MER people, but I think this is my 26th year.
Oh my gosh! You're also you're modest about this, but very highly rated because I've seen some of the reviews. So
which
go ahead.
Kind of baffle me because I don't really consider myself to be an expert in anything, but I do think that the MER, which stands for those people who are new to this or managing electronic records, that the MER conference is the best forum in North America for practical discussions of managing information technology, more from the substantive point of view than the technological point of view. Now, we have a lot to offer. Myself and my colleagues in the Sedona conference on those issues from the legal viewpoint. But more importantly, we have a lot to learn from the people who are attending who are actually in the trenches. And we don't get that if we're simply talking to legal academics and judges. We need to be outside of our bubble, and MER is a much bigger bubble that we can participate in. So we reconnect with the real world by attending, and then the MER attendees get the same quality of legal education that a federal judge would get. So they're hearing the same things from me and my colleagues that federal judges are hearing in circuit judicial conferences. So I think it's a great relationship.
So one last question, and then I'll let you go. And this is, I usually refer to this as my country western song question. Is what, you know, we're both at kind of like a certain point in our careers. So what do you know now that you wish you knew then?
Message to my younger self. You are not invulnerable or immortal. You need to take care of yourself physically and mentally. So eat your vegetables, floss your teeth, get your annual checkup. And when your knees start hurting at the 60-mile point of your 125-mile bike ride, stop. Just stop. The t-shirt at the end of the race isn't worth risking knee replacement surgery.
Oh.
So that's my advice to my younger self.
Good advice, and good advice no matter what the age. So, Ken, thank you so much for being with me today. I've really enjoyed the conversation. I'll look forward to sitting down and chatting with you at MER in May. And thanks again. I really appreciate it.
Well, thank you for having me.
Take care.
Bye-bye.